Okay, so I want to see if we can get through a few more of these, right? So we're sticking with our disposition without trial techniques, right? So these are all the things you can do to get that early, possibly complete win for your client without the cost and time consumed with going to trial. We talked about two of them already. Let's come now to this one, determination of an issue without trial. Okay, so you had Rule 21 on this. This is the second half of Rule 21.01, right? We already looked at the first half with striking out pleadings. And this is used when there is a question of pure law, right? So, so sometimes we can resolve civil litigation quickly and cheaply because we just have to make a legal decision. We don't have to get into any facts at all. And that's what this rule says. And once again, we see that no evidence is admissible when we're talking about this, because the whole point is you only use this tool when you've got a pure legal question you can resolve and thereby end the case, right? So this is supposed to be like a ridiculous joke, like a mockery of the civil justice system, but it actually is what we do when we're using this rule. Okay, and the case that explains this is this quite tragic case of Maher Arar. People may be familiar with his legal odyssey, which was a really black stain on the Canadian legal system in many different ways. But we're talking about here in the context of this particular rule. So, so Maher Arar was detained in September of 2002 at a Canadian airport, or sorry, actually in a New York airport, on suspicion of being a terrorist. He was held for 2 weeks in solitary confinement, and then he was flown to Jordan and then flown to Syria, where he was held in captivity for 10 months and was tortured. He was completely innocent. He had no connection to terrorism whatsoever. There was a big inquiry, and it emerged that he had actually been arrested in New York because the RCMP had falsely labeled him as a terrorist and provided this incorrect information to the Americans. So, so he received a $10.5 million settlement and a public apology from the Prime Minister. He also sued Syria and Jordan, right? The countries which had perpetrated this torture and captivity upon him. So Jordan, the government of Jordan here is asking to dispose of this without a trial, right? To get rid of his lawsuit against them on the basis of Rule 21.01. So what they say is that as a matter of law, we are always immune to claims of this nature. No matter what awful stuff we did to this guy, no matter what the merits of his case may be, as an absolute matter of law, we are immune. What's their legal argument? What's the statute that they say lets them off the hook? Yes, that's right, the State Immunity Act, which creates a straightforward blanket immunity to foreign states from civil actions in Canada. So for various reasons collected to political science and international relations that we don't need to get into, it's almost impossible to sue a foreign state in a Canadian civil court. Okay, so that's the statute they're relying on. No statute, of course, can displace the Charter. Maher Arar has a Charter argument to the effect that this torture he is subjected to violates his Section 7 rights to life, liberty, and security of the person, and that this State Immunity Act is incompatible with the Charter and sort of the Charter protection for his rights and security of the person have to be read into the State Immunity Act. And he's got some legal basis for that. There's this Suresh case that he's standing on there, right? So it's a constitutional argument against the State Immunity Act. But the thing is, it wasn't properly pleaded. So that's the other reason why I like this case. It illustrates Rule 21, but it's also a great reminder to plead expansively. Because there actually was this Charter argument that could have been in his pleadings initially or could have been added to his pleadings, arguing that the Canadian federal government was complicit in the foreign government's violation of his Charter rights, and therefore the Charter basically has to be applied, and you have to read it into the State Immunity Act. But he failed to plead that. So, so he loses on the basis of Rule 21, right? Because there's a statute that says this type of claim cannot be made, and none of the legal ways around that have been properly pled. An exception was later added to the State of Unity Act in response to this case to let Canadian citizens sue foreign states in cases like this, but he was out of luck on this one. So I think that's all I wanted to say about that. It's one to remember when you think there is a clear legal argument. We saw something kind of similar with the case from last time, the Maguna case. Remember where he sued so this guy who was arrested, charged with sexual assault, arrested in an unnecessarily embarrassing way. He brought this claim against the police. He brought the claim against the Queen and the government. But there was a very clear legal provision the government could rely upon saying you have to give us 60 days of notice before you bring a pleading. He didn't do that, so it's just gone, right? Yeah, so effectively, I mean, the rules were slightly different at that point, but this case illustrates this rule. The 21.01 sub 1 sub A rule, right, where there's a question of law that can be resolved without actual debate. Okay. Moving right along, we have discontinuance and withdrawal. So Rule 23 tells us what happens if a plaintiff starts an action and then wants to drop it, right? Wants to end that action. Under what circumstances can the plaintiff discontinue and withdraw their claim? And so that's what Rule 23 answers. So the first thing to know about this is that a plaintiff can discontinue and drop their case unilaterally before the close of pleadings, right? Close of pleadings, you remember that there's a stage, there's kind of a threshold in the case after the pleadings are all in when we're going to be moving on to discovery. If the plaintiff decides they want to drop their case before that point, they can do so without getting anyone's permission. And they just have to file this form. Now, it's fits in with the kind of liberal approach we have towards pleadings, right? You may recall that if you want to amend your pleadings, you can do that without getting anyone's permission or bringing a motion as long as you do so before the close of pleadings. So it sort of follows that if you can amend your pleadings, you can also likewise drop it. Now, you may be on the hook for costs, right? If a plaintiff brings a claim and then drops it, then the defendant can seek costs on the grounds that they had to spend money responding to this claim that the plaintiff just gave up on, but the claim itself can be dropped unilaterally. Okay, so that's before close of pleadings. You can also, of course, discontinue your claim at any time by filing the consent of all parties. Right, which doesn't sound like much, but this little rule, 23.01 sub C, is actually how the overwhelming majority of civil litigation ends. Because this is what you do when you settle. You file these forms to say the case is over, none of us want to go forward with it, probably because some kind of compromise has been reached. Okay, so that leaves the question of what happens when the plaintiff wants to drop their claim, pleadings have closed, and there is no consent from all parties. So this is kind of a weird idea, right? A plaintiff wants to stop litigating against the defendant. Why on earth would the defendant not say, fine, let's forget about it, right? I mean, no one likes being sued in the first place. Why would a defendant withhold their consent to the discontinuance and withdrawal of a plaintiff's claim? And if the defendant didn't want to, then why would the court require consent, right? The courts have a policy of promoting settlement. So it seems at first counterintuitive, right? And I scratched my head when I read this rule for the first time. Why wouldn't the courts say, okay, go away, we don't want to deal with you anyway, you settled, good for you, we're not going to insist on anyone's consent. So this next case kind of answers those questions, right? The case of Simanic versus Ross. Based in St. Kitts, which looks pretty nice from the picture at least. So this case is about why defendants don't necessarily want to let plaintiffs drop their case and the circumstances in which courts will grant leave to discontinue and withdraw when the plaintiff withholds their consent. So Michael Simanic is a real estate developer and Anthony Ross is his lawyer. So they're based in Canada, but they do lots of work in St. Kitts. And the story starts back in 1992, where Simanic has this resort project that he's building in a place called Frigate Bay. And the resort project goes off the rails. Ross was his lawyer, right, in some old litigation from 1992 related to the demise of this resort construction project. And Simanic and Ross get into a dispute about Ross's legal fees. It's not in the judgment, but Simanic basically says that he retained Ross on a contingency basis, and they have a dispute about that. So the court sides with the lawyer, right? The client sues the lawyer, Simanic client sues the lawyer Ross. The court issues a judgment for Ross and says Simanic has to pay $107,000 to his ex-lawyer Ross in legal fees. That judgment is never satisfied. Right, so these guys are they're still beefing 10 years later, and they have this old judgment debt, and they're mad at each other. Okay, so flash forward to 2001. Ross, the lawyer, is retained to act against his old client Simanic. So someone else hires Ross to sue Simanic, and Simanic is not at all happy about this. Right. Has anyone taken the legal profession and able to tell us anything about kind of the legal ethics of this? What's it called? Or what potential ethical problem arises when your former lawyer acts against you? It can be a conflict of interest, exactly right. Yeah. So you know, it's a complicated theme in legal profession, but basically in some cases you have the right as a client to not be sued by your lawyer. Like, for example, they can never switch sides in the case that you're fighting and start acting against you. It's completely unrelated. Usually they can. Anyway, it doesn't matter. But this is the kind of dispute this is, right? And clients hate it when their former lawyer acts against them because they tend to have the belief that that lawyer is going to be their ally permanently, and they're not pleased to be sued by them. Okay, so this is a case where he's suing for damages for breach of fiduciary duty, which is related to this conflict of interest. Okay, so, and the concern often comes down to confidentiality, right? Because when you retain a lawyer, in the course of the lawyer-client relationship, you will often provide information to them, confidential information, which could be used against you in the future, right? And clients have the right to total confidentiality. Right? The lawyer must never divulge any confidential information they've received from the client over the course of a retainer. And in a case like this, right, like suppose this Simanic, this developer guy, like he tends to use shoddy materials in his resorts. And when Ross was his lawyer, Ross had reason to learn that from him. Now Ross is suing him and maybe in a position to use what he knows about Simanic from his own previous retainer against him. Okay, so the whole dispute, the whole 2001 dispute is about these conflict of interest rules. And it arises from events that take place in St. Kitts. And okay, so Ross is now suing Simanic in St. Kitts. Simanic says, you can't be acting against me. One thing Simanic could have done is brought a motion within the St. Kitts court, right? Because he's being sued in St. Kitts. Simanic could bring a motion to the St. Kitts court to say, Ross has to be disqualified and can't act against me because I'm his former client. He has confidential information about me. But instead of doing that, Simanic sues Ross in an Ontario court. Right? So it's complicated, right? There's a St. Kitts action where Ross is representing someone suing Simanic. Simanic is pissed off because Ross used to be his lawyer, but Simanic chooses to strike back by suing Ross in an Ontario court, alleging this conflict of interest. And Ontario and Simanic can do that because Ross lives in Ontario. So paragraph 6, there is an initial flurry of activity, pleadings go back and forth, but then the matter languishes for many months, right? So nothing happens. We know about the party control principle, that generally in civil litigation, nothing happens unless one or the other party takes some action to move things forward. In this case, that did not happen for many, many months. Simanic then sues Ross in St. Kitts about the same thing. So he's now suing him in 2 different jurisdictions about the same fundamental complaint. The next thing that happens is Simanic says he wants to drop the Ontario motion, wants to drop the Ontario action, right? He wants to discontinue and withdraw his Ontario action against his former lawyer, Ross. So why on earth didn't Ross consent, right? No one likes being sued. No one likes being sued in two places at once. But if the person who sued you is offering to let you out of the Ontario action, why wouldn't you leap at the opportunity?
He wanted his name back cleared. One of his motivations.
Yeah, he wants to win. He wants to win, which may be about his name and his reputation, but it's also about like the legal risk, the exposure to a future judgment. Okay, so let's kind of try to unpack that. He has got the important thing to note about this rule here is that it does not prevent you from suing about the same thing again in the future. Right, so this is 23.04 sub 1. The discontinuance of all or part of an action is not a defense to a subsequent action unless the order giving leave to continue or consent filed by the parties provides otherwise. So what does that mean? That means if you've been sued about something and the person who sued you discontinues and withdraws their claim, that does not stop them from suing you about the same thing again in the future, right? So it's not a defense for you to say they already sued me and dropped it themselves. And the reasons for that are a little bit obscure. Okay, so this has to do in part with negligent lawyering, right? Sometimes you will bring an action and your lawyer will botch it. It happens depressingly often. Litigation is complex, right? We all make mistakes. Or sometimes you'll run out of money. Or there's several other reasons why you might discontinue and withdraw, but not because the claim is devoid of merit, right? So we have this rule to say that, you know, sometimes the plaintiff should get another kick at the can just because they discontinue and withdraw, and it might have been their lawyer's fault. So we're not going to prevent them from suing again about the same thing. So this is probably maybe going through Ross's mind, right? That you know, if I let Simanic out of this Ontario action, that doesn't mean he can't come back after me again in Ontario about the very same thing. Whereas if we proceed and have this adjudicated, or if Simanic agrees to drop it and release me from it permanently, then Ross is a lot better off, right? So that's one piece. The other thing is the fact that there are these disputes going on in 2 jurisdictions at once, right? Simanic suing Ross both in St. Kitts and in Ontario about the same thing. So if Ross lets Simanic out of the Ontario action, he's still on the hook in St. Kitts. And he would rather defend it in Ontario than in St. Kitts, because Ross is based in Ontario. It's cheaper for him to defend in Ontario. So he would rather, he might well let Simanic drop the St. Kitts action, right? So they can fight it in Ontario. Because if he fights it in Ontario and wins here, then it'll be res judicata, which is to say that order will effectively, is very likely to convince the St. Kitts case that Ross should win there too. Okay, so I guess what I'm trying to get across is that having the plaintiff discontinue and withdraw their suit against you sounds great, but it's not as great as it sounds. At least it's not as great as it sounds unless the plaintiff is willing to sign a release saying they'll never sue you about it again. And that's why this defendant chose not to consent to the discontinuance and withdrawal. Okay, so that means we have to go to court, right? The court has to apply 23.01 sub 1B. They have to decide whether to give leave for Simanic to drop his Ontario case. So it's a long case. It gives some of the historical background that we won't talk about. But paragraph 25 gives us the key test here, right? So paragraph 25 The court to balance and weigh the rights and interests of the parties. It is to consider the prejudice that would befall the plaintiff in not being permitted to discontinue against the prejudice to the defendant if leave were granted. Prejudice, right? We see this word in practically every case about civil procedure, because so many of these kind of discretionary leave decisions are about prejudice, about disadvantage to one side or the other, right? And trying to be fair to both, thinking about what we can do with costs and what we can't do with costs. So, so we're looking at both sides. Like on the one hand, you know, we want to promote settlement. It's the plaintiff's case, so it's like it should be, they should be allowed to. That's a reason to let them drop it. But from the defendant's point of view, the plaintiff has forced them to walk down this long road of the conventional civil action. Right? The plaintiff has forced the defendant to spend time and money defending, and the defendant will be much better off if it reaches a final adjudication forever, or the plaintiff drops the case while giving a release, providing assurance to the defendant that they won't be bothered with the same claim ever again. So that's the test, and then they balance it here. They say it's certainly relevant. The stage we're at in the proceedings is certainly relevant, right? We know that plaintiffs can discontinue and withdraw unilaterally after the close of pleadings. If pleadings just closed last week and the defendant has not yet spent much time and money on discovery, then there's a pretty darn good chance we're going to grant leave to the plaintiff, right? Because the defendant doesn't have much skin in the game yet. So if more time has happened, then that's relevant. In cases like this, where there's a parallel proceeding, meaning that the parallel proceeding in St. Kitts means that letting the plaintiff drop their Ontario case doesn't mean there's going to be peace, right? It's not like these guys are going to bury the hatchet. It just means they're going to go fight it out in some other jurisdiction. So that's an argument against granting leave to discontinue and withdraw. So those are factors that are worth keeping in mind. So the motion is denied, right? And Simanic will not be allowed to discontinue and withdraw, which is weird, right? I mean, you can't frog march someone. Like, there's not like they're going to send the sheriff to Simanic's house and make him show up in court to conduct a discovery. What it means de facto is that Simanic is going to have to sweeten the pot, right? Simanic is going to have to make a better offer to Ross to get Ross's consent for the Ontario action to be dropped. And that might mean more money, or that might mean an offer to drop the St. Kitts action as well, or it might mean a release, providing Ross assurance that he won't be sued about this in Ontario again. Okay, any questions about that?
How long is the close of pleadings?
So the close of pleadings, there's timelines. We're not really doing timelines in this course, but it's a matter of weeks after statement of claim. The defense has to be issued, and then the plaintiff, in some cases, has the right to issue a reply. Right? We talked about that. So after the reply, typically pleadings are closed. It depends a little bit on jurisdiction, but it's a matter of weeks after the statement of claim. So quick, right? In the 2-year lifespan of a case. Okay, do we have time to talk about default judgments? No. Not really, right?
No, just try to
give them this. Okay, all right, that's okay. Thanks for being with me, and I'll look forward to seeing you next week.